Hey folks, this is your accountant Mansoor Sohail. I operate out of Toronto, Ontario, and my specializations are taxes for Canada and USA. My today's presentation is for educational purposes only. It does not constitute any legal advice or opinion, so please do not use any of its contents without seeking a professional advice. I will be talking about shareholder agreements today. A properly drafted and executed shareholder agreement is a legally enforceable contract. It is effective as soon as signed and remains in force indefinitely. Purpose. Purpose of the agreements is to record agreement on issues related to the organization. An agreement can address a single issue or many issues. There are many different types of agreements. Non-unanimous agreement. These agreements will address narrow issues and are used to create a block of shareholders that can present a common front at shareholders meetings. Unanimous agreements. These type of agreements are signed by all shareholders and represent all owners of the corporations. The unanimous shareholder agreement is an extremely useful tool for shareholders in small corporations who wish to ensure that they will retain control of the company. It is recommended to create unanimous agreement in the beginning of corporation's existence. Pledge agreements. A pledge agreement can ban pledging of shares as security for debts or require that all pledges include an agreement by the creditor that in the event of default of the loan, the shares will first be offered for sale to corporation or the other shareholders at a certain price, with the proceeds being used to satisfy the debt. Voting agreements. A voting agreement may have a clause appointing one or more parties as proxies for others. A proxy is an instrument that entitles one person to vote on another's behalf at a meeting. Comprehensive shareholder agreement. Comprehensive shareholder agreements can include all or just some of the corporation's shareholders, but usually take the form of unanimous shareholder agreements. These agreements address different aspects of corporation's affairs, like bylaws. Agreements may have clauses that set out the rules for choosing the bylaws. Share ownership. Agreements may have clause that sets out how the shareholders require the corporation shares to be allocated. The clause will indicate the number and the class of shares going to each shareholder and the purchase price of these shares. Issuance of new shares. Preemptive rights clause and prior consent clauses are the most common clauses with regards to issuance of new shares. A preemptive clause states that if the corporation wants to raise money by issuing and selling more shares, it must offer the new shares to existing shareholders before offering to anybody else. And each shareholder has the right to purchase enough shares to maintain the same percentage ownership of the corporation. In a prior consent clause, the corporation is barred from issuing new shares unless it obtains the prior consent of the existing shareholders. Transfer and sale of existing shares. Clause controlling the sale of existing shares may give existing shareholders the preemptive right to purchase the shares offered for sale by a fellow shareholder, or may simply state that a sale can proceed only with the consent of others. These clauses may include pledge agreement, a clause regarding the disposal of a shareholder's share after death, or a clause requiring shareholders to sign prenuptial or marriage contracts protecting their shares from a division of assets on a marriage breakdown. Buy-sell agreements. Buy-sell agreements allow shareholder A to force shareholder B to either buy A's shares or sell his or her own shares to A at a pre-established price. This kind of agreement gives every shareholder the right to initiate the buy-sell mechanism. Death legal incapacity or bankruptcy of a shareholder. An agreement can have clause designed to ensure the smooth running of the corporation on death, legal incapacity, or bankruptcy of a shareholder. Director. An agreement can be used to control the election powers, remuneration, and replacement of directors. Similarly, an agreement can set out rules for appointment, powers, remuneration, and replacement of officers. Financial issues. A unanimous agreement can dictate how certain financial issues are dealt with by the corporation. Dispute resolution. An agreement can contain clauses for dispute resolution. Lawyer's reporting letter. So, what is it? It provides a comprehensive review of the work carried out by the lawyer. Following are the issues that can be addressed or discussed in the reporting letter. Basic information, searches performed, shares, directors, officers, meetings, minute book and seal, shareholder agreement, enclosures, account and trust statement. Thank you for listening, folks. This information comes from the Fundamental of Corporate Law and Procedure, written by Mark Wilma and Patricia McCann Smith, publishers Edmund Montgomery Publications Limited, Toronto, Canada. Thank you once